speaker, Professor Wasim Ali Saab, and I am reading his profile, and it is also very long. So I'll point out some of his achievements. He has LLM, LLB from AMU, then LLM from AMU, PhD from AMU, and and he has qualified NET and Judicial Services examination for civil judge in 2000. He has a teaching experience of 19 years since 2016. He was associate professor. He was become associate professor in 2012, and then in 2016 he became professor. His specialization is Muslim law, and he has been teaching different at LLB and LLM level, Muslim law relating to status, Muslim law relating to poverty, Hindu law, and law of affairs. He has supervised 5 PhD scholars, and many. He has published 28 articles. He has published paper in 26 seminars and conferences. He has supervised 28 dissertation, and there are many more to say about him. But I will hand over this session to Dr. Mohd Wasim Ali. Go ahead, sir. Thank you.
Over to you, Wasim. Over to you.
Okay. Thank you, Madam Dr. Faiza, as well as Dr. Moisa.
You are also needed to unmute yourself.
No. We can hear him. We can hear him.
Yes, I'm audible, I think. I'm audible.
Yes, you are audible. Yes. You're audible, sir.
So, first of all, I would like to place my sincere thank to Dr. Faiza for inviting me and giving a chance to share my ideas and views with the teachers, Karim City College. I'm also thankful to Dr. Mohd for introducing me with the participants. As Dr. Faiza has pointed out that since I'm looking after the work of Proctor, but really for so many years I wanted to be associated with this HRD center and wanted to have a discussion and wanted to share my views and ideas with the teachers from various parts of the country who used to join this HRD center under a certain banner. But ultimately, I got this chance. Last time, a few days back, I was invited, and then again, I got this chance. So once again, I'm thankful to Dr. Faiza and her team. Ladies and gentlemen, as all of you are teachers, maybe in the college or maybe in the university, and maybe of any discipline, but ultimately we all are teachers. And being the teacher, I don't think that or I don't find myself competent to teach the teachers. But definitely, being a teacher in terms of seniority, it will be my privilege to share my ideas with regard to the teaching. And just before getting on the topic or a subject that I want to discuss, I would like to say something about the profession, that is teaching profession. Teaching profession all over the world is supposed to be the noble or the best profession, because this is the profession which directly contribute to the nation building, and therefore this profession is considered or is regarded as noblest profession among all. And I myself prefer to this profession because as uh, Dr. Mois uh, in his introductory remarks pointed out that I was selected, and in fact I was finally selected as civil judge junior division in 2000 batch. But and it was my final selection. I was given appointment by the High Court of Allahabad, but I retained this appointment for 3 years, and after 3 years, I tendered my resignation, wrote to the governor of the UP as well as the Chief Justice of Allahabad High Court, and I preferred teaching over the judicial service. Otherwise, today, by the grace of Almighty Allah, I would have been in the rank of district judge, or may have been elevated even to the High Court if everything would have been well and in my favor. But I prefer to the teaching uh, because I was having the 100% choice. I was appointed as uh, a lecturer, assistant professor through a general selection committee in the same year 2000. In the month of August, I was finally selected as judicial officer, and in the month of March in the same year, I was appointed as assistant professor through general selection committee. Therefore, I was having the full opportunity or option either to join that very service or to this service. But ultimately, I prefer to this for various reasons. I don't think it is the proper time to discuss all those things. But I never regret for not having gone uh, in judicial services. Whereas sometimes people ask my friends, family members, and those who come to know. Even sometime my student also question as to why did I not join judicial services. I used to give the reasons, various reasons, but in fact, it was my passion, and it was, and I prefer to this because of some reason that this is the profession. In fact, once a teacher goes to the class and delivers to the best of his abilities, and when he comes out, that gives a lot of pleasure to the teacher, unparalleled pleasure. There is no any alternate for that pleasure which a teacher enjoys after coming out from the class, if he has really delivered his best to his student. So this is therefore I think this is a simple and best profession. But uh, there are certain responsibilities and certain duties attached with this teaching profession. And one of the responsibility is that we should try to be honest with ourselves as well as with the stakeholders. And stakeholders, of course, are our stakeholders, are the stakeholders with the teachers, are none other than the students. Because in this is the only profession of which there is no immediate scrutiny. Almost in all the jobs, there is scrutiny of the work. There is a process for the evaluation of the working of a professional, maybe engineer, maybe doctor, even judicial services also. If a judgment is given by the officer of the lower rank or lower judiciary, there is a provision for appeal before the appellate court, that is before the district judge. Then there is an appeal for before the provision for appeal before the high court. Then there is a provision for appeal before the Supreme Court, and even uh, there is a provision for mercy appeal before the President of India. This is the provision under the Indian Constitution. If there is a doctor and somebody is being treated by a doctor and one is not satisfied, then he can go to a doctor of another expertise, uh, of higher experience, of good reputation, meaning thereby that by leaving one doctor in appeal, he can go to another doctor who is having more expertise, more experience, more reputation in his field. Even all the profession, there is a process for evaluation of the work which is delivered or which is performed by a particular professional. But this is the profession wherein there is no provision for evaluation of the teaching performance of a teacher. If I am a teacher in faculty of law, I go to my class, I may teach whatever may be the quality of my teaching in the classroom. A dean or chairman never go along with me, sit in my class, or take the note of my teaching, way of teaching, contents of the teaching. Nothing is evaluated by chairman or dean. Even other officers of the university, maybe the vice chancellor, maybe the pro vice chancellor, maybe the principal or anybody else. Who is our evaluator? Who is or who are there in the class or in the classes? That is the students. But due to the hierarchy or due to the relationship between the teacher and student, they never come out with the objection that, sir, you did not teach well or you did not teach to my satisfaction. Therefore, again, it is left to the self-evaluation. Did I really was I really to the satisfaction of our student? After class, we can evaluate ourselves and can arrive on the conclusion that did I justify my presence in the class or not? Because from the face reading of the student, teacher can understand what kind of the performance he is delivering, or what kind of the performance in the classroom he has delivered. The faces of the students, basically they perfectly indicate our performance or the performance of a teacher in the classroom. And therefore, just I said that if I have to the satisfaction of the student, nothing can be more satisfying than this, that we have been to the satisfaction of our students. Therefore, just I told that we should be very honest, because nobody is there in the classroom to monitor my performance or the performance of a teacher. It is the self evaluation that sometimes makes to one realize as to what quality of the teaching or work he has done today or on a particular day in the classroom. Therefore, I must be very honest, or teacher must be very honest when he is in the classroom. And to be honest, it is necessary that we should go well prepared in the classroom. If we are not well prepared in the classroom, we cannot, meaning thereby we are not doing the justice, not only with our profession, but also with the stakeholders who are the future of this nation. Uh, that is the student of the class. So this is the basic responsibility of a teacher, that we should be very honest uh, with our profession, with our teaching, with our student. Really, if we are honest, then just I told that nothing can be more satisfying than this. And perhaps, therefore, this profession is said to be the best profession or noble profession among all. Ladies and gentlemen, this is just a kind of uh, sermon as a teacher, I think. Uh, and uh, everybody or anybody can give this type of sermon or a teaching or lecture or advice, suggestion. But this is from my side a kind of suggestion to all those who are participant over here in this event or in this program, which has been organized by the HRD Center for the orientation of the teachers of the Kareem City College. Now, in addition to this, from my area of specialization or teaching, today I want to discuss some point which may be of common interest. I have been teaching family law that uh, comprises Muslim law as well as Hindu law. In addition to this, I have also taught constitution, law of evidence, as has been pointed out by Dr. Moise while introducing me. And I have developed interest particularly in constitutional law, because uh, this is also a very uh, interesting area of the teaching, particularly in the field of law. But at the same time, the other subject that I have been teaching, that is family law, especially Muslim law. The various aspect of the Muslim law has been in controversy, giving rise to a number of litigations from High Court to Supreme Court. For example, in recent time, there was controversy regarding the uh, triple divorce or mode of dissolution of marriage, because uh, marriage is a uh, union between the two persons of the opposite gender, and the formation of this union basically takes place with the mutual consent of two persons, normally one male and other female. And when the two persons of the opposite gender, with their mutual free consent, agree to live with each other, forming a conjugal society, such union is basically called as union of marriage across the religion. Maybe the Hindu religion, maybe the Muslim religion, or maybe Christian religion. The basic and fundamental concept of marriage is that it is a union of the two persons who have decided to live with each other with their mutual consent in accordance with the rules and regulation governing to their uh, uh, community. But once a union has come into existence, this union confers a status, and that status is the status of husband and wife. Once a marriage has taken place, it has come into existence. Immediately after the marriage, formation of the marriage, uh, one party acquires the status of the husband and the other party is given the status of the wife. And this status also gives certain rights to the parties concerned. Means the husband is given certain rights against the wife, and against a wife is having certain rights against the husband. And they are known as the mutual spousal rights and obligation arising from the contract of the marriage. One of the right arising from the contract of the marriage, that is the reciprocal right, that after the marriage, parties also have the choice either to continue in the marriage or to put to end to this union which was uh, formed in due form or according to the law applicable to the parties concerned. Ladies and gentlemen, for a longer period of the time, the procedure of divorce are prescribed or provided by Muslim law. I am talking especially about Muslim law of divorce, because the Muslim law of divorce has been a point of controversy for a longer period of the time. You can say that from the day of enforcement of the constitution, or when the constitution came into force, from the first day of the enforcement of the constitution, this mode of the divorce or procedure prescribed for the dissolution of the Muslim marriage has been examined by the legal luminaries in the light of gender equality, which is enshrined in Article 14 and Article 21 of the Constitution. And therefore, the law of divorce, Muslim law of divorce, has been subject of criticism or subject of the debate from various point of view, from constitutional point of view, from bar to bench. And therefore, time to time, this mode of the dissolution of Muslim marriage has been a challenge before the Supreme Court in the light of the relevant provisions of the Constitution, that is taking the help of Article 14 and Article 21 of the Constitution. The mode of the divorce as recognized under Muslim law have been challenged, and the courts have taken the opportunity to adjudicate upon the mode of the dissolution of Muslim marriage. The most controversial part of the Muslim law, right from the very beginning, has been the triple form of the divorce, or that is known as triple divorce or talaqul biddat. This is also called as talaqul biddat. This has been a very controversial area, and from the British period since 1939 or till the judgment of the Supreme Court in Shaira Banu versus State of Jharkhand, uh, which was decided in 2018, and then later on, pursuant to this decision, a new law was enacted by the BJP government in 2019, that is known as Muslim Women Protection of Rights on Marriage Act 2019, whereby the triple divorce has been declared as illegal and void. This is one set of the controversy regarding the procedure of divorce as the or the mode of the divorce as prescribed by Muslim law, because Muslim law is based on the Sharia, that is on the uh, Holy Quran as well as on the saying of the Holy Prophet. Therefore, in 2018, the matter was finally settled by the Supreme Court. What is the status of triple divorce? In the light of Sharia, that is, in the light of the Holy Quran, saying of the Holy Prophet, vis-a-vis Article 14 and Article 21 of the Constitution, as well as Article 25 of the Constitution was also taken into account while dealing with the validity of triple divorce by the Supreme Court in Shaira Banu case. Ladies and gentlemen, uh, as you might have read the newspaper, and in various newspaper, uh, the judgment ratio of this judgment was published, and the comments were also published for and against the judgment which was given by the Supreme Court. And Supreme Court ultimately declared the triple divorce as void, means not enforceable in the court of law. At the same time, it was also held that this form of the divorce is illegal, violative of Article 14 and Article 21 of the Constitution. And the Supreme Court in detail gave the reasons as to why this form of the divorce, which has been recognized under the Muslim personal law as one of the modes of the pronouncing the divorce, is illegal, void, violative of the relevant provisions of the Constitution, that is Article 14 and Article 21 of the Constitution. And further also, the Supreme Court clarified that this form of the divorce, that is the triple divorce, is not having the protection of Article 25 of the Constitution, because defense party was taking the argument that this divorce is part of the Muslim personal law in view of Section 2 of Muslim Personal Law Sharia Act 1937, because under Section 2 of Muslim Personal Law Sharia Act 1937, what constitutes Muslim personal law is indicated. Clearly, it is indicated. And one of the integral part of the Muslim personal law is law of divorce, along with the marriage, dower, maintenance, guardianship, inheritance, waqf, gift. In addition to this, divorce is also one of the component of Muslim personal law in view of Section 2 of Muslim Personal Law Sharia Act 1937. And therefore, Muslim Personal Law Board and other who were parties defending the writ petition filed by the Shaira Banu, because Shaira Banu challenged before the Supreme Court that triple divorce is violative of Article 14 and Article 21 of the Constitution, not having the protection of Article 25 of the Constitution. Therefore, this law or this form of the divorce should be declared as null and void, because it is also against the spirit of gender justice, which is integral part of the Article 14 and Article 21 of the Indian Constitution, and therefore her prayer was that this form of the divorce being discriminatory, violative of the gender justice, violative of the principle of equality, violative of the or violative of the personal liberty of the individual women, as well as it was also argued that this form of the divorce is also not commanding absolute sanction of the Holy Quran or the saying of the Holy Prophet, which is the bedrock of the Muslim personal law as enforced in India for the regulation of certain matters, just like marriage, dowry, divorce, maintenance, etc., etc. And therefore, the petitioner was before the Supreme Court with the arguments that a piece of law or part of the law or principle of law which is violative of the principle of natural justice, violative of the principle of equality, violative of the principle of life, liberty, as given under Article 21 of the Constitution, not having the protection of Article 25 of the Constitution, which guarantees the freedom of religion. At the same time, a point of law or a portion of Muslim personal law which is also not having the absolute sanction or approval of the Holy Quran or saying of the Holy Prophet, how can it be regarded as a good piece of law? And when a piece of law is not good, is not having the sanction of the fundamental uh, principle of constitution or the Sharia law, how can it be a good piece of the law? And if it is not a good piece of the law, then how it can be uh, applicable to the Muslim, and when it is against the interest of a larger segment of Muslim society, that is the women, because the women are the real victim of this piece of the law which is known as tateful divorce. Ladies and gentlemen, the Supreme Court examined the validity of this mode of the divorce in the light of two relevant laws. One, set of the law which is the base or which is the genesis of Muslim law, that is the Holy Quran as well as the saying of the Holy Prophet. The validity of this law was examined by the Supreme Court in the light of the Sharia, that is in the light of the Holy Quran, as well as in the light of the relevant saying of the Holy Prophet. Also, it was examined in the light of the views of the four major schools of Muslim law, that is Hanfi, Maliki, Shafi'i, and Hanbali law, including the Shia laws, Shia schools. At the same time, the Supreme Court also took the note of Article 14 and Article 21 of the Constitution. And ultimately, the Supreme Court arrived on the conclusion in the case of Saira Banu versus State of Jharkhand that this piece of the customary law, which is recognized as one of the mode of the dissolution of Muslim marriage, is illegal and white. Illegal means that henceforth, if any Muslim husband will pronounce the triple divorce or will dissolve his marriage by resorting to the triple formula of the divorce will be liable to be punished because will be liable to be punished. What will be the punishment? The Supreme Court stated that it will be later on decided by the government in power by legislating appropriate law on the subject. At the same time, the Supreme Court also declared it unconstitutional or being violative of Article 40 and Article 21 of the Constitution and not having the protection of Article 25 of the Constitution. Pursuant to this decision, the government, central government enacted a piece of legislation that is known as Muslim Women Protection of Rights and Divorce Act 2019. This is a very small piece of legislation, but it was enacted by the government prima facie to provide the protection to the Muslim women who, according to them, normally happen to be the victim of tyranny of the Muslim husband who set aside his wife sometime in anger or emotion just by pronouncing the three divorces. And therefore, a specific provision was uh, enacted, that is Section 3 of the Act, that is Section 3 of the Muslim Women Protection of Rights and Divorce Act 2019. That is important provision under the scheme of this Act, and it provides that henceforth this Act will be applicable to all the Muslim across the schools, and it will be applicable to whole India, including the state of Jammu and Kashmir. And the most important provision under this law is Section 3, because Section 3 of the said Act declares triple divorce illegal and void. Means, after coming into force of this Act, if any Muslim husband pronounces triple divorce or dissolve his marriage by pronouncing the three divorces simultaneously upon his wife, then he will be guilty of an offense under Section 3 of Muslim Women Protection of Rights and Divorce Act. And at the same time, the provision was made that if somebody has pronounced the three divorces upon his wife in violation of Section 3, then he will not only be liable to be punished, but marriage will not dissolve. Marriage will remain intact, but he will be guilty of a matrimonial offense and will be liable to be punished. And the punishment may be up to 3 years imprisonment or with fines or with both, that is 3 years punishment and maybe a fine also. When this law was enacted and was enforced and made applicable, this piece of the legislation was subjected to criticism by various legal luminaries, lawyers, judges, social activists, And a number of the ideas or the criticism were published in the daily newspaper. And one of the potential criticism of this piece of the legislation which was enacted by the government in power in 2019, now of course at that time and even today, the central government is the government of the BJP party. So one of the criticisms of this law which was enacted by the government was that what will happen to a wife whose husband has been sent to the jail for 3 years after the pronouncement of 3 divorces in violation of Section 3 of the Muslim Women Protection of Rights and Divorce Act 2019. Means if somebody has pronounced the 3 divorces upon his wife and wife files a complaint, FIR, case is registered, a trial is held, and ultimately he is convicted for 3 years or for 2 years. But at the same time, this pronouncement of the 3 divorces by the husband will not have any negative or adverse impact on the validity or on the status of the marriage. Marriage between the husband pronouncing the divorce and the wife who has filed or lodged a complaint against the husband seeking his conviction for the wrong done by him, that is for pronouncing the 3 divorces upon her. That husband has been sent to the jail, but marriage remains intact. It does not affect adversely the status of the marriage. She remains the wife of the person who has been jailed for 3 years for his wrong of pronouncing the divorce 3 times upon her, upon the complainant. And therefore, the wife cannot choose any other person of her choice once the husband has been sent to the jail, because still she remains the wife of that very person who is guilty of the 3 divorces in view of Section 3 of the Muslim Women Protection of Rights and Divorce Act 2019. He will remain in the marriage of the same person who has been sent to the jail on the complaint of the wife. So who will take care of the maintenance of that very wife as well as of the children once the husband has been sent to the jail for such a longer period of the time, that is 3 years? Who will take care of the maintenance of the wife? Who will take care of the maintenance of the children born of such wedlock? Maybe the 2 children, maybe the 3 children, maybe the school going children, and the father was taking care of their expenditure before going to the jail on the application or complaint of the wife who was subject to the 3 divorces by the erring husband. So what will happen to the family members? And at the same time, not only the wife, not only the children, what will happen to the old age parents who may have been dependent on the earning of the person who has been sent to the jail for 3 years on the complaint of his own wife? Therefore, there was a criticism that if triple divorce is not recognized as a form of the divorce as it was earlier to this decision, then of course the triple divorce, if declared as illegal and void, at the same time it should be made effective that after the pronouncement of the divorce, husband will be the guilty of violating Section 3, but at the same time it will have the effect of finally dissolving the marriage, so that after the complaint, husband has been is subjected to the punishment, and wife will be at liberty to go on her own way, searching uh, for her new life partner, because she may be because of the dispute of serious nature, husband might have given the divorce, and his intention was not to continue with her. But now, in this situation, a very complex situation is created by this piece of the lesson. So this was the criticism. And now, moreover, that a person who is coming back serving the 3 terms, 3 years jail, will be in a position to continue his marital life with a woman on whose complaint he was sent to the jail or has been sentenced to the jail for 3 years. This is also a question. Will there be harmonious life between the complainant and the person against whom the complaint was lodged? Whatever could have been the attending facts and circumstances of the complaint, whatever could have been the pronouncing, whatever could have been the reasons for pronouncing the divorce by the husband upon his wife, irrespective of all these considerations, point is that basic object of every law is welfare of the people. Here, in this context, the people are the husband and wife, as well as their dependents, maybe the children, maybe the old age parents. So whether this piece of the legislation is really intended to foster welfare of the people, because the genuineness of the law is basically tested on this parameter, because every law is enacted by the competent authority or body, maybe the parliament or maybe the state legislature. Basically, every law is enacted for the betterment, for the welfare of the people, maybe of a particular community, maybe of a particular group, maybe for a particular or a larger group of the society. But ultimately, aim of every law is to resolve the problem, not to complicate the problem, to minimize the suffering of the people, not to continue with the suffering of the stakeholders. So on this parameter, the validity or the genuineness of law is examined. Now, there is a recent development and the judgment of the Supreme Court in context of religious places of worship act, uh, which was enacted long back when after the demolition of the Babri Masjid. Religious places of worship act was enacted, and basically this law was enacted to not only to protect the religious places, but in fact the spirit behind this enactment was to foster or to maintain the communal harmony in the country. But of late it has been it was noticed that by invoking certain provisions of this act, the various lower courts have given the order for the survey of various religious places, leading to the communal tension in various parts of the country. And ultimately, again, the matter was uh, with the Supreme Court, and the Supreme Court again has given a verdict and has put a stay on the survey or entertaining the litigations or complaint or application pursuant to this act, because uh, it is not in the larger interests of the society at large, not only for the Muslim society, but for the whole country. Now, the Supreme Court, a division bench of the two judges, headed by Chief Justice of India, Justice Sanjeev Khanna, has put a permanent stay that no court below the Supreme Court will entertain any litigation under this provision, because entertaining any kind of the litigation pursuant to this act will lead to the communal disharmony or disharmony between the communities, which may not be in the larger interests of the country, and therefore this type of the verdict has been given by the Supreme Court. Uh, Ladies and gentlemen, uh, not only this has been the controversial part of Muslim personal law, one, and therefore the Supreme Court almost has set to rest the controversy regarding the modes of the dissolution of Muslim marriage, and therefore earlier, before the passing of Muslim Women Protection of Rights and Divorce Act 2019, as well as the decision of the apex court of the country in Shaira Banu case, uh, there were three modes. There were three recognized mode of the dissolution of Muslim marriage. One was, rather you can say broadly speaking, there were only two recognized modes of the dissolution of Muslim marriage. One was known as Talaqul Sunnat, and other was known as Talaqul Biddat. Talaqul Sunnat was further classified into two classes. One is known as Talaq Ahsan and Talaq Hasan. And this second form of the divorce, which was called as Talaqul Biddat, or it is also known as triple divorce. Therefore, now the triple divorce is no more a recognized form of the dissolution of Muslim marriage after coming into force of this Muslim Women Protection of Rights and Divorce Act 2019, uh, specifically in the light of Section 3 of the said Act. Now, therefore, at present, there are only two forms of the dissolution of Muslim marriage, or there are only two recognized formula in the exercise of which a Muslim husband can repudiate his duly solemnized marriage. And one is known as Talaqul Talaq Ahsan, and other is known as Talaq Hasan. Uh, I think that this is all of you may not be well informed about all these, not being uh, related to the law discipline, and therefore there is a lot of confusion and misgiving about. There has been a lot of the misgiving about the dissolution of Muslim marriage or Muslim law of divorce. One confusion was, or misgiving was, regarding the recognized mode of the divorce, and other misgiving has been regarding that under Muslim law only husband has got the power to dissolve the marriage. and women are the wife under no circumstance is competent or entitled for separation or claiming the separation. This is a totally misinformation or misgiving or misunderstanding. And therefore, uh, so many time critics of this part of the law have come out with the statement that Muslim law of divorce is derogatory to the dignity and status of the Muslim women and violative of the principle of equality as enshrined under Article 14 of the Constitution, as well as it is an encroachment, arbitrary encroachment upon the personal liberty of an individual, women, which is also guaranteed under Article 21 of the Constitution. And therefore, after coming into force of this Constitution, these modes of the divorce are no longer valid, because if anything is in violation of any provision of Part 3rd of the Constitution, no law, may be statutory or may be customary, will be regarded as valid and enforceable in the court of the law. So one thing has been settled by the Supreme Court, that henceforth triple divorce is no more a valid form of the divorce. Only the valid form of the divorce, according to the Muslim law, are either talaq-e-Hasan or talaq-e-Hasan. And even talaq-e-Hasan is also under challenge, along with the uh, another aspect of this law that is known as halala, that is also pending before the Supreme Court. And the petitioners are trying to argue or convince the court, and succeed to convince the court, that even talaq-e-Hasan is also not a valid form of the divorce under Muslim law, like triple divorce. And therefore, this formula of the divorce should also be declared illegal and void, as it has been declared illegal and void by the court so far as the triple divorce is concerned, because their argument is that according to the Quran, which is the fundamental source of Muslim law, which is the paramount source of the Muslim law, in view of uh, verse 222, verse 1 and 2 of Surah Talaq, only recognized for valid form of the divorce is talaq-e-Ahsan. And they are also trying to develop the argument that Ahsan formula of the divorce is only the valid form of the divorce, because it commands not only the approval of the Holy Quran or saying of the Holy Prophet, but at the same time, it is also in consonance with the principle of equality and principle of natural justice, which are uh, inbuilt in Article 14, provisions of Article 14, Article 21 of the Constitution, that therefore, according to the petitioner, uh, only the formula of the divorce to be valid and recognized after coming into force of the Constitution, particularly part of the fundamental right, is Ahsan formula of the divorce, and therefore rest formulas of the divorce as recognized in past should be done away, declared illegal and void uh, by the Supreme Court in the exercise of the power of the judicial review, as well as uh, explanation of Article 21 and Article 14 of the Constitution. And there is possibility of uh, decision even on this point also, and the court may come out declaring even talaq-e-Hasan and halala as unconstitutional as well as the violative of the principle of gender equality. Uh, on the grounds that it is not only violative of constitution, but it is also, they are also violative of uh, rules or principle dealing with such matter even in the fundamental sources of Muslim law. Friends, why that talaq action is regarded as only the formula of the divorce? There are reasons, because uh, in Ahsan formula of the divorce, a Muslim husband is required to pronounce the divorce only once in a specific period, only one divorce. And after pronouncing one divorce, if the parties are not pulling on well, they are not on good terms, or they are not having the good relationship with each other for whatever reasons, the nature of the dispute may be based on anything, uh, but irrespective of nature of the dispute, if parties are not pulling on well, they are not on good terms, they have lost are losing the uh, mutual confidence in each other, and the mediation and reconciliation has also failed, because uh, Muslim law, that is the Holy Quran, basically is a very practical religion. And therefore, it is provided that under the scheme of life divorce, that if at any point of the time the parties are not pulling on well with each other, they are disputing with each other for whatever reasons, then rule requires that before proceeding for separation, first of all, they should refer their point of the dispute or point of the disagreement to the arbitration, meaning thereby that a arbitration board should be constituted. An arbitration board should consist one person from the family of the husband and other person from the family of the wife. And point of the dispute should be referred to the arbiters. And arbiters are required, and they are commanded by the Sharia law, that they should make a sincere effort to bring the reconciliation between the parties by counseling them. And in case their sincere effort fail to bring them on the good terms, and point of the dispute is not resolved, then they will make the recommendation for their separation, and then the parties can proceed to separate from each other by means of the divorce. And then further the procedure requires, law of divorce requires, that if at all the reconciliation has failed and the relationship has poisoned to such an extent that they have gone to the point of no return, only in this circumstance they are allowed to separate from each other, but they cannot separate from each other just like a passenger or passengers standing at the railway platform waiting for a train, and the train has arrived at the platform and they will say goodbye to each other and they will board the respective train. No, because this is a unique relation. Marriage creates a unique relation, and therefore this unique relation should be maintained as far as possible. Even in the adverse situation, parties should make their all possible effort to maintain the relationship created by means of the marriage. But if at all the situation warrants that continuity of the relationship is not possible, or due to the attending facts and circumstances, then in such situation, the better option is that parties should separate from each other, and further they are can choose the life partner of their respective choice for the rest of the life. But a due procedure has been prescribed by the Muslim law for separation even in the most adverse circumstance. And what is the procedure? Procedure is that if at all efforts have failed to bring them on good terms, then the husband can pronounce or will pronounce only one divorce upon his wife, that too in a specific period. And after pronouncing the divorce, the wife will wait for next 3 months in the same matrimonial home and will be entitled to be maintained by the husband who has pronounced the divorce in the same way, in the same style as she was being maintained immediately before the pronouncement of the divorce. And wife will be the wife upon whom the divorce has been pronounced one divorce by the husband. She will be required to wait in the same matrimonial home for next 3 months. This is a sufficient time. And this period is called as waiting period. This period is called as iddat period. During this iddat period, again, the parties are required to reconcile their point of differences leading to the pronouncement of the divorce. And therefore, the parties are required even after divorce to live together in the same house, in the same matrimony. And if at any point of the time during this period, parties realize that they have committed a blunder and this action of the parties is likely to jeopardize, harm not only their mutual interest, mutual life, but it will also have the adverse impact on the life of their dependents, family members. If this type of the realization is felt by the parties at any point of the time during this period of the 3 years, they can come back with each other just by maintaining the physical relation. Nothing is required. Before the expiry of the 3 months, during this period of the 3 months, if the mistake is realized, they can rectify it by reverting back to each other, and again uh, they can continue as husband and wife without any harm. Nothing is required. On the expiry of the 3 months, if no reconciliation has taken place, they have insisted on their decision. They continue, they maintain their decision. Then on the expiry of the 3 months, marriage will finally dissolve. And on final dissolution, the parties will finally separate from each other. All the relationship created by marriage will stand terminated on the expiry of the period of the iddat. Means they will be no more entitled to be called as husband and wife for each other. Since they will not be husband and wife for each other, therefore they will not be entitled to have any right or obligation, or will be entitled to claim any kind of the rights or obligation against each other. Marriage will finally dissolve. This may be one situation. But even after the final dissolution of the marriage, if again after some time they realize their mistake and again they want to reunite, there is a possibility of reunion. And the reunion can be possible just by contracting a fresh marriage. Just by performing the nikah, they can again reunite, they can come back to each other. And they can start their life afresh. Again, at any point of the time further, after some time, again, suppose there is a dispute because friction in such type of the relation used to happen. And again, if there is some due to certain reasons there is a dispute and dispute could not be resolved, and again the husband has pronounced the divorce. Again, one divorce is given. Wife again will be required to wait for 3 months. During 3 months, again they will have the opportunity to reconcile with each other. If reconciliation could not be possible, again on the expiry of the period of 3 months, marriage will finally dissolve. And after the final resolution of the marriage, if again they want to reunite, they have realized their mistake late, and again they want to reunite, they can reunite with each other. And again, just by contracting the fresh marriage, there is no need of any intervening process, which is normally called as halala, etc., etc. Up to here, there is freedom of reunion, even after final resolution of. But again, there has been dispute between the parties, husband and third time, at any point of the life, if the husband pronounces the third divorce, so this will be the third divorce. Thereafter, they will have no chance of reunion because uh, in the fundamental sources of Muslim law, that is Holy Quran, it is specifically provided that divorce is permissible only twice. Before pronouncing the third divorce, there should be final decision. Before he should think before pronouncing the third divorce, because that will be the last opportunity. Second was the last opportunity. Thereafter, if any divorce is pronounced, that will separate the parties permanently, and thereafter they will have no chance of reuniting with each other. And therefore, this formula of the divorce is known as the Ahsan. Ahsan means the best formula of the divorce recognized under Muslim law, approved by the, and this formula of the divorce is recognized, is approved by the Holy Quran as well as the saying of the Holy Prophet. And there is a absolute agreement among all the schools of the Muslim law, including Shia law, that this is the only formula of the divorce recognized under the Sharia law, that is the Holy Quran as well as the saying of the Holy Prophet. And there is a total agreement, there is absolute agreement, there is no dispute or difference of opinion among the schools of Muslim law, maybe Hanafi law, Safi, Maliki, Hanbali, or Shia schools. All the schools are in agreement that the correct formula of the divorce recognized or provided by the Muslim law is that which is called as the Ahsan formula of the divorce. And this divorce formula of the divorce is the best form of the divorce, because not because that Islam wants the divorce, rather this is called as the best form because in this formula of the divorce there is full reflection of the principle of natural justice, which is the cardinal principle of Article 21 of the Constitution of India. Here in this formula of the divorce, there is enough opportunity of reconciliation to resolve the point of the dispute, to revert back to each other, to continue in the union of the marriage, and at the same time both the parties are afforded the opportunity of being heard to each other. And a longer period of opportunity is given to the parties to look into their decision and to revise the decision. And procedure for the revision is also very simple, harmless, And therefore, this principle or formula of the divorce is said to be the best form of the divorce, because it is in the interest of the parties that they should try to maintain the union of the marriage as far as possible until the death of either the. This is the mandate of the uh, Holy Quran itself. But if the situation, a difficult situation has arose and it has become inevitable, even under the inevitable circumstance, parties are afforded a space, further space is given, further opportunity is given to review their decision, having regard to the future interests of their dependent, maybe the children, maybe the parents, maybe the family members, maybe their family values, maybe the societal values. So having regard taken into account the totality of the circumstances, still they have the chance to review or their decision, which has been taken in the form of the divorce. And therefore, since the principle of natural justice is fully reflective, and this formula of the divorce is based basically uh, on the gender equality, that here both the parties are placed at equal footing, in the sense that if the dispute has arose between them, they can resolve their dispute by inviting one person from the family of the wife, another person from the who may be called as in technical sense as arbiters, or and they are required to make the effort to bring them on good terms. If that fails, only then the divorce is allowed. Otherwise, you see that, and normally this is there is allegation that under Muslim law, the law of divorce is very loose. And at any point of the time, husband can pronounce a divorce with reasons or without reasons. Well, practically it happens because of the ignorance. Otherwise, Muslim law is very, because divorce is said to be most detestable among all the permissible things, permissible things in the sight of Almighty Allah. This is the mandate in the Holy Quran, that of all the permissible things, divorce is most detestable. And Allah does not like person who frequently marry and frequently divorce. This type of the mandates are given in the books of the Hadith as well as in the Holy Quran. And uh, Holy Quran desires that since marriage is a serious social institution, therefore the parties should make all possible effort to maintain it as far as possible, even in the most difficult situation, it should be maintained. And if at all it has failed, only then it can be divorce is allowed. But there is a procedure how to separate. A very decent procedure has been laid down by the Sharia law uh, for separation of the parties to a marriage. And that procedure is that is the procedure of talaq ahsan, or formula of talaq ahsan. Talaq Hasan is also recognized on the basis of the interpretation of the Holy Quran, which is the genesis of the law of this Ahsan formula of the divorce. The same words has been interpreted, and by means of the interpretation, it has been accepted by the jurists of the Islam, that even if a husband pronounces one divorce in one period and other divorce in another, then up to 2 months, again he has the right to revert back in case the matter has been resolved. But in third month, if the divorce is pronounced, so in talaq ahsan, 3 divorces are pronounced in 3 consecutive months. So, and this formula has been evolved on the basis of the verse which has given rise to the talaq ahsan formula of the divorce. But this is the lesser accepted formula of the divorce. There is a difference of the opinion among the jurists of the Islam. All the school do not even accept to the Hassan formula of the divorce, and therefore, taking the advantage of other interpretation, petitioner has gone to the Supreme Court, and the matter is pending before the court that since the talaq Hassan is also a controversial formula of the divorce. Therefore, like triple divorce, this should also be done away. Only one form of the divorce should remain recognized, that is talaq ahsan, which is in conformity with the provisions of the Holy Quran, saying of the Holy Prophet, as well as is in consonance with the spirit of gender equality, as well as uh, uh, principle enshrined under Article 21 of the Constitution, which is uh, the heart and soul of this. The fundamental rights are the most precious right guaranteed under Article 20, under the scheme of the fundamental rights. Uh, Ladies and gentlemen, uh, this was a point which I wanted to share with all of you, because we may belong to any ideology, any school of the thought, any religion, but ultimately we are the part of a composite society. And therefore, the responsibility or onus rests on us to educate the people of respective surrounding, that what sometime happens in the name of the right is not right, rather it is wrong, and this wrong practice, which is the customary practice, should be given up, not be followed, and this requires the proper counseling and education. A proper counseling and education program is initiated in a given society. I think that many families can be saved from being shattered and separated because of a wrong notion that under Muslim law, the husband at any point of the time can pronounce the divorce and can done away the institution of the marriage, and can destroy or dismantle the institution of the marriage, which is most sacrosanct or bedrock of the society. This is not so. This is a very wrong notion. Uh, Basically, this is uh, a kind of propaganda against the fundamental principle of Muslim law, and this is because of misunderstanding, ignorance by the people of the Muslim society itself. Because when we are not aware about the basic things, how can we make aware others? And therefore, this is since what I have discussed, that is that normally happens in the Muslim society, and you might have experienced that sometime a very pathetic situation arise when uh, the parties met, and they start putting up their grievances, and the state of the situation or the condition in which after separation they are and their family members are. So I think that there must be some kind of the clarification on this point, and this clarification was necessary because even the uh, people of the Muslim society themselves are not clear as to what is the exact law on the subject of divorce, as prescribed by the Holy Quran, saying of the Holy Prophet, as well as the schools of the Muslim law, uh, including the Shia schools. So now this is all about one topic, whereas today I wanted to discuss something else, because today is the Minority Rights Day, because on this day, uh, General Assembly, United Nations General Assembly adopted a resolution in 1992, on 18th December 1992, recognizing the significance of minorities in a given society. Rights of minorities, this day were declared as Minority Day, and since in recent past, Aligarh Muslim University has been in the limelight pursuant to the Article 30 of the Constitution, uh, uh, and the Supreme Court declared the Aligarh Muslim University de facto as minority institution, abolishing the Aziz Basa case. I wanted to basically discuss on this point, but I shifted my uh, focus from this, because that is very complex issue, and still because our matter is pending before a three judges, a bench of three judges for final decision. Therefore, I did. I thought that it may not be better, but today is Minority Day, and this day is celebrated all over the world, recognizing the significance of minorities in a given socio-political setup. We will have the chance to discuss even on this matter also. What are the rights of minorities? What is the nature and scope of minorities' right, particularly with reference to the right to establish and administer an institution of a choice by the minorities, linguistic minorities, religious minorities, ethnic minorities, because this is the bifurcation of the basis of the minorities. So these minorities have been given the right to establish and run an institution of their own choice, in the exercise of right enshrined under Article 30, subclass 1 of the Constitution. And why this right has been given to the minorities, this is clear from the mandate of Article 29 of the Constitution, because Article 29 of the Constitution guarantees the conservation and preservation of cultures, tradition uh, of a particular group or community. So both the Article 29 and 30 are very important in present context, political context, and therefore sometime, if we have the chance, we can discuss what is the rights of the minorities, with special reference to the right to establish and administer an institution of their own choice, and what is the significance of this right in contemporary scenario. Uh, Today, even a very elaborate article has been published in the Hindu uh, newspaper, and that article again has come from a very uh, known jurist, Professor Faizan Mustafa. So I request all of you to go through this article of Professor Faizan Mustafa, that will enlighten you regarding the significance and the scope of this right, which is given to the minorities of different classes pursuant to the Article 31 of the Constitution of India. Though all the rights given under the chapter of fundamental rights are very important, significant for the dignified survival of uh, citizen of this country, but Article 31 and 29, they are very important for the dignified survival of the minorities maybe the religious minorities, maybe national minorities, maybe the linguistic minorities, or maybe any other kind of the minorities as recognized by the constitution itself. So this is all about today's uh, lecture. Now I'm open to ask any question or any clarification with regard to the point that I have made, uh, addressing to the participant, or maybe any other point uh, which requires the clarification. So all of you are welcome in the form of question. Uh, and now from my side, uh, it is over.
Dear participants, you may ask the questions.
Hello,
जी जी
sir.
वेलकम.
I am Hindu by birth, but
हम्म
I don't know about Muslim personal law. I
हम्म.
want more one or two session in regarding these topics.
Regarding okay, okay, okay.
These topics.
Same topic.
Yes, sir. The related topics, sir.
Yes, 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 yes.
Thank,
So
thank you, sir.
I hope that in future we will have the chance to
Oh,
discuss something more in detail.
yes, sir.
And
Yes.
comparative study, comparative discussion can also be initiated because so far as marriage is concerned, marriage is mm, a common socio-legal institution recognized under all the uh, uh, communities, religious communities, maybe Hindu religion, maybe Hindu community, maybe the Muslim community, maybe the Persian community. So this is the and therefore this is called as socio-legal institution. This is the bedrock of the society, and therefore where there is an institution of the marriage, there is a possibility of dissolution of the marriage because by means of the marriage, two persons unite with each other, and by means of the divorce, the circumstances forced to separate the parties who were united with each other by means of the marriage. So, what are the grounds for the dissolution of marriage under Muslim law? What is the procedure prescribed for the separation of the parties under? And in the same way, under the Hindu law also, marriage is well defined. Conditions for marriage is also defined, laid down.
Yes.
And at
Yes.
the same time, what are the grounds on which a Hindu marriage can be dissolved by decree of divorce? So that is also there is a section 13 subclass 1 subclass 2 of the Hindu Marriage Act 1955 because the Hindu law is fully codified on this subject. Muslim law is uncodified still. Only a limited portion of this subject is codified. But so far as the Hindu law is concerned, Hindu law is fully codified. Parsi law is also, Parsi community is also governed by a separate law, that is Indian Succession Act, Indian Marriage Act. But all these laws are codified. So under in what circumstance or in what condition a Hindu marriage is allowed to be dissolved, or court can pass a decree of dissolution of the marriage. So these are also the points to be known to the parties, to the people of the society, because we are living in a dynamic society, in a living society. And being the member of a living society, at least we must be aware about the laws which are governing or regulating our personal matter, our family matters, which are known as the part of personal laws. Law of succession,
Thank
you
you.
see that law of succession is also most important. How that in case owner of if there is a owner of properties and he dies, so who will be entitled to succeed his properties or his leftover? Under Muslim law, under Hindu law, both there is separate laws providing the separate rules regarding the devolution of the interest of a deceased in his or her property. Say, for example, if somebody dies leaving behind 1 crore rupees in the State Bank of India and deceased is Muslim, so who will be entitled to succeed the amount left by him in the State Bank of India in cash? If the party is non-Muslim, maybe Hindu, then who will be entitled to succeed? What law will be invoked in order to determine as to who can be allowed to withdraw the money from the State Bank of India after the death of the account holder. So, and under Muslim law, if the party is Muslim, then who will be entitled? And what will be the share of the individual claimant? Because if the owner dies, or account holder dies, leaving a crore of rupees, and there may be so many claimants. So, out of so many, who will be the best entitled? And among entitled, what will be the share of the individual? Either all will be equally entitled or their claim will vary from person to person, from claimant to claimant. Law is very clear on these points. But many people don't know that what will happen in case such type of the situation arise, which law will be applied. क्योंकि हम लोग जाकर के बैंक में जाके खड़े हो जाते हैं कि साहब ऐसा है, मैनेजर साहब हमारे फादर की डेथ हो गई और हम 2 भाई 3 बहन हैं और हम बस आप हम 2 भाइयों को दे दीजिए। तो अब वहां पर झगड़ा खड़ा होता है। अब एक मसला आता है कि क्या क्या जो बहनें हैं वो भी इंटाइटल हैं कि नहीं है, यानी जो एक आदमी जिसकी डेथ हुई उसकी लड़कियां भी हैं, लड़का भी है, उसके मान लीजिए उसकी मदर भी है, पार्टी मुस्लिम है, पार्टी नॉन मुस्लिम है, अकाउंट होल्डर नॉन मुस्लिम है या मुस्लिम है, तो विच लॉ विल बी अप्लाइड इन ऑर्डर टू डिटरमिन द क्लेम ऑफ स्टेक होल्डर्स and how the share of the individual will be determined. So these are the uh, matter of common interest, common knowledge, and I think that not only law person should know it, but ये जागरूक पीपल ऑफ द सोसाइटी, मतलब जो हम सभी लोग जागरूक होना चाहिए अपने राइट्स के बारे में, क्योंकि अब वक्त और जमाना बदल रहा है। तो अगर हम अपने राइट्स के बारे में जागरूक नहीं होंगे, और जागरूक होने के लिए जानकारी होना जरूरी है, और जानकारी होने के लिए मेरे ख्याल से इस टाइप की मीटिंग होते रहे तो अच्छा रहेगा। विद दिस आई थिंक देयर इज नो क्वेश्चन फ्रॉम एनीवन ऑन द सब्जेक्ट आई हैव डिस्कस्ड विद ऑल ऑफ यू। और बताए भाई कोऑर्डिनेटर साहब।
शुक्रिया सर, बहुत बहुत शुक्रिया। आपका ये लेक्चर बहुत ही डिटेल्ड था, डिस्कसिंग अबाउट ट्रिपल तलाक एक्ट, प्लेसेस ऑफ वर्शिप एक्ट एंड इवन राइट ऑफ मैनिटी। आपका जो ये डेलिब्रेशन था बहुत ही डिटेल में था एंड बहुत सारे कंफ्यूजन्स जो सोसाइटी में है उसको दूर करता है। Thank you for your lecture, sir. Now, I would like to ask Kasturi Barik ma'am to propose vote of thanks. Kasturi Barik ma'am from Women's College, Jamshedpur. Women's. Ma'am.
Yes, hello sir, am I audible?
Yeah, ma'am.
Yes, you are audible.
Yes, sir. Well, it was a very kind and very sincere lecture from your end, sir. And it was very much knowledgeable regarding the law of talaq. And as I'm also from a Hindu background, I didn't knew about the laws made for the like talaq and all, and it was very much knowledgeable for everyone, I guess, not only from the background of professionals but also from the background of other knowledgeable institutes. Well, it was very kind of you, sir, for giving insightful thoughts and insightful knowledge regarding this petition. And also, thank you for giving your time for this lecture and giving your time to the professors.
Thank you very much. Thank you very much.
Yes, sir.
Okay, sir.
Thank you.
Now I quit.
Okay, sir. Okay. Allah Hafiz. Participants, कल फिर मिलेंगे at the scheduled time. Thank you.
ठीक, शुक्रिया शुक्रिया।